Can a prenuptial agreement be overturned? My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. Can you overturn a prenuptial agreement? It's a great question. You know, there was a movie years ago called Bonfire of the Vanities starring George Clooney. And George Clooney played a role of a high-powered lawyer, and his name was Massey, and he wrote a prenuptial agreement, and his prenuptial agreement was supposed to be ironclad. And the whole movie was about ironclad and whether or not his agreements could be pierced, and nobody ever pierced his prenuptial agreements. Well, I got to tell you, in Michigan, there is no Massey prenuptial. There is no ironclad prenuptial. Prenuptial agreements can be pierced as required and as determined by the court that's necessary to do so to protect the principles of equity. What does that mean? It means we got to be fair. Now, when we talk about fairness, we've got a couple things going on. Number one, a prenuptial agreement is a contract. It is subject to being enforced and attacked like any other contract. So we start out with the proposition that we have an agreement. We had a meeting of the minds. There was consideration. So the parties should be bound to uphold that agreement. On the other hand, just like any other contract, we have to look at it. Was it entered under duress? Is there some reason why we shouldn't uphold the agreement? Was the agreement given to the bride as she was walking down the aisle? If so, it's probably going to be indicated that that's something of duress and probably is not going to be enforceable. Was there an opportunity for the other party to take the agreement to counsel of their own, to take a look at it, to negotiate it, to see whether or not it's an agreement that the parties really want? Do they have a meeting of the minds? So number one, you got to look at the viability of the agreement. But more important than that, you have to understand one thing. If the agreement is viable, if it meets appropriate standards, the court sure will try to honor it, but it doesn't have to, because even a perfectly legitimate, viable agreement, the court can look at the change in circumstances and say, you know what, I appreciate the terms of this agreement and I will honor it in part. However, provision C2-5, I'm not going to honor because I don't feel that it's fair given the change of circumstances. I'll give you an example. The court might say that the agreement requires that if the parties split up, that the person gets $500 a month alimony. That's the agreement. The problem is that you have one person who's the payor and one person who's the recipient. The payor is a millionaire. The recipient doesn't work. Now, during the marriage, 10 years into it, the recipient became very, very debilitated and ill, and now requires a lot of nursing care and a lot of this, a lot of that. Well, the $500 a month from the millionaire is not going to cut it. There's been a change in circumstances. So the court can uphold the agreement, but can say, you know what? In light of the circumstances, I'm going to order $1,000 a month alimony or $2,000 a month or whatever the court deems fair. What I'm illustrating to you, and which should come across clearly, is that the court's got a lot of leeway here. The court will look at the agreement and try to enforce it, but at the same time has the ability to go beyond the agreement and pierce the agreement as justice requires. If you have any questions about your prenuptial, reach out and we'll be glad to help you out.